where we stand in the scheme of things, because we're talking about the Attorney General here, Minister of Justice. We're talking about the office itself. And so it promises to be a very good conversation. When I come back, I will be introducing my resource persons. You don't want to tune off. Stay tuned in. All right, welcome back. It's about the back and forth between the NDC and the NPP and that explosive tape that was played or was released by the NDC yesterday at a televised presser where the Attorney General and Minister for Justice, GODFRED Dame, is heard in a telephone conversation with a third accused who is also a witness in the trial of an ambulance case before the court, and the legal and ethical issues that have come up as far as yesterday's press conference was concerned. So the NDC makes the allegations, the MPP comes to rebut it and say that everything the NDC has said indeed is not true. In fact, they raised three issues. One, it is not true that the tape that the NDC has played, according to the MPP, is doctored, is not authentic. And number three, they've also said that one of the reasons why the NDC is doing everything, we're doing this to the Attorney General, is because the Attorney General has been perhaps or arguably the most successful Attorney General we've had in this country. And they give us a litany of reasons to back that and to say that the NDC just personally dislikes the Attorney General. That encapsulates everything that the MPP said in that press conference. Let's listen to, in brief, or just briefly, excerpts of that audio. And then when I come back, my guests are seated. I have lawyer Kweku Pencil. He's a private legal practitioner. And I'm also going to be talking to Justice Abdullahi, who's also a private legal practitioner. And then Adib Sani, he's a security analyst. Now, Adib comes in handy because Adib is going to be telling us, when we talk about a doctor tape, what does it mean? And how do we determine what a doctor tape is? What are what kinds of technology do we have now to be able to try or to be able to test the authenticity of a recording, for instance, and so on. So there's a whole conversation that we're going to be having. More importantly, where do we go from here? So let's listen to this just briefly, and then I will introduce my guest one more time.
You pay only after the goods have been delivered, because that's also the contract, not so.
Yes, but then the financial instrument for the project is an irrevocable letter of credit. So
Good.
So that credit letter has already been sent.
Hold on, no problem. But in my view, that letter of credit area, the contract requires that you pay by letters of credit, not so.
Yes. In addition, we should establish it upon the sign of the contract. So already you have paid.
Upon the sign of the contract for every 50 ambulance.
Yes. Upon the signing of the contract for every 50 ambulance, since there was no advance mobilization, advance payment, that LC was a security that you have to establish ahead.
No problem. It's on the contract for every 50 ambulance. Is it the contract for every 50 ambulance?
Pardon?
Is it the contract for? I'm saying upon the sign of the contract for every 50 ambulance.
Yes.
Is it the contract for every 50 ambulance?
The contract is for 200 ambulances in tranches of 50.
Good, hold on. So that contract for 50 ambulance is different from this one?
No. The contract is one contract for 200 ambulances, which has been broken down within the contract for every few. You establish LC for every 50 tranche. So you have 4 LCs for the 200 ambulances.
No, that part I disagree with you. But if you look at the terms of the contract, it's quite clear. And it should not be difficult for you to accept, because really it doesn't put you in any problem at all. That does not put you into any difficulty. And you know the Minister of Health, the Minister of Finance. So for me, if you accept that, then it doesn't put you in any difficulty.
See, the problem I have in accepting that for you is that in there are letters that confirm that, both from government and from our principal, that is for every 50 ambulances. That confirms that. And I'll be tendering those letters in. So I cannot go against what the letters say and the contracts say, because I was the agent at that time. JAKPA business was the agent.
Hold on. LCs on site. Payment shall be in euros. First, we said there shall be no advance payment.
Yes.
What does advance payment mean?
What it means is that you are not the supplier was not going to be paid any cash, any money for him to use in procuring all the accessories and everything to manufacture. So the manufacturer will use his own money to buy the ambulance vans, all the accessories from across the globe, with the security from government being the LC. And the LC has conditions precedent.
Hold on. Bridget, yes, advance payment don't mean paying in advance of the delivery of the goods.
They said no advance payment.
Yes, advance payment means that you are paying before the goods are delivered to you.
No, they said no advance payment. Not that there's advance payment. Yes. No advance. Mean that you will not pay.
Yes, until the goods are delivered to you. Also.
Yes.
Yeah, so until the goods are delivered, you don't pay at all.
You don't pay.
Also. So, and then also it goes ahead to say that payment shall be in a free manner. LCs on site of goods. In fact, what is it, even LC on site of goods? What does it mean?
What LC on site of goods means is that when you ship the documents, when you ship the goods, when you ship the goods from your port of origin, the bill of lading of the goods is what you use as
LC on site of goods means when the goods have been shipped.
They have been shipped.
Not and then the goods have been delivered in Ghana.
No, when the goods have been shipped. Because you have gone to do pre-shipment. So what I'm trying to explain is that so you use the bill of lading. You use a bill of lading. You use a bill of lading.
You establish the LCs after pre-shipment inspection. No dispute about that.
No, the LC is established as soon as you sign the contract. You establish the LC, and that becomes the security comfort for the supplier to invest his money.
It says LCs on site of goods are reserved upon the signing of the contract.
Yes.
For every 50 ambulances.
Yes.
Yes. Which contract is this? It's not a contract for every 50 ambulances. So in under this main contract, this was like the main contract.
The main contract and LC for every 50 of the 200. So the contract is not saying that government should establish one LC which is 15.8 million euros for the whole 200 at a go. No. Government has a bulk contract of 15.8 million euros. Now, this contract will become, the ambulance will be coming in tranches of 50 ambulances. So you establish your LC for the 50. When that 50 have been delivered and everything sorted out and handed over, another LC is established for another subsequent 50 until you finish all the 200. That is what the contract says. So the LC that was established.
Even then, hold on. I don't agree with your explanation. But even then, this explanation, that's not what happened in this case.
Okay, what happened?
Yeah, that's not what happened. Yes, because the LC was established even before pre-shipment inspection.
Yes.
Also,
yes.
There was no pre-shipment inspection. So it have been so it means there was no basis for the LC to be established in the first place.
No.
That's really not your problem anyway.
Right, that place.
All right, welcome back. Now, you heard that telephone conversation between the Attorney General and Mr. Richard JAKPA. He's a businessman involved in this, and of course, it's called the Big C. He's involved, in fact, he's associated with Big C, which is a company that deals in the manufacturing of vehicles. And then also or ambulances more specifically. And then also you heard the Attorney General in that conversation with the man. And that has been the subject of a widespread conversation that's taking place within the media circles as to the propriety or otherwise of this conversation. So we're going to be talking to the lawyers to pick their views on this matter. But the 0244-262-314, 0244-262-314, 0244-262-314. That's the WhatsApp line for those of you who have views that you intend to express on this matter. And as usual, I'll be more than happy to hear what you think of this conversation or this discussion or this issue. So I'll say that Adib Sani is also a security analyst. He'll be joining us via Zoom shortly. Justice Abdullahi will also be joining us shortly. as far as this matter is concerned, so they can give us their view. But here in the studio, I've got lawyer Kweku Pencil, who is a private legal practitioner as well. Sir, thank you very much for accepting to join us. Good afternoon.
Good afternoon.
Right. So for you, what issues arise after listening to this tape? Whether borders on law, whether borders on ethics, whether borders on morals, what are the issues that you think we must look at?
I think first, talking about issues, we remind ourselves that there is an ongoing trial.
Absolutely.
In respect of this matter.
Right.
And the issue that arises, or the issues that arise, relates to the propriety of everything that is being done in connection with the matter that is being actively tried in a court of law. The first point I'd like to make is that there are accused persons in court who are being tried for a criminal offense. As far as I understand, it's about some 2-point-something million euros regarding some contract that the state believed it was done on the blind side of the law. And essentially, they have been put on trial. The issue that has arisen now relates to alleged conduct by the Attorney General,
right,
as the one who is actively prosecuted in the case. And I think the starting point is the allegation by the witness in the witness box that the Attorney General somehow tried to compromise him.
Right.
I mean, in connection with the trial.
Right.
Now, because of the hue and cry that has arisen, it's important to point out that we have a law in this country relating to matters that are in court which the parties may wish to settle.
Right.
There's nothing absolutely wrong with either party to a criminal matter or even a civil matter wanting to settle out of court.
Right.
But there are rules regarding settlement out of court. In the criminal trial, we've got the plea bargaining law.
Right.
The essential character, or what in relation to what's going on, the first point that we like to observe is that if parties want to settle a matter and the parties are represented by lawyers, then the matter is properly settled or properly confronted or properly talked about between the lawyers. Now, in the particular context of this case, the Attorney General is the lawyer for the state.
Right.
And therefore, if he wishes to initiate any discussion with a view to a settlement or anyway, it's not only settlement. Some of the negotiations could involve getting some of the parties on one side to turn over to your side. There's nothing wrong with that.
There's nothing wrong with that?
Absolutely nothing. If you go back to the U.S. as I'm speaking right now, one of the several suits against Trump, the Attorney General has successfully succeeded in getting about 4 of the accused persons to come on the Attorney General's side on various agreements by which they've agreed to give evidence against Trump, even though they all started the suit charged with the same or similar offenses and whatever. So it is a practice. I mean, it is of the essence of a trial that the parties should be able to settle out of court. And for that purpose, the law tries to aid them within confined guidelines, if I may put it that way.
Okay.
That is why we have this plea bargaining law in this country. And the plea bargaining law, the essential character of the plea bargaining law is that if the person is represented by a lawyer, then the negotiations must take place with a lawyer. I take the benefit of what appeared in our papers. I mean, over the weekend, I think Justice Shremsai is the lawyer for these people.
That's Big C.
Yes.
Big C, the Big C Company Limited. That's Richard JAKPA.
No, Justice Shremsai, that's the name of a lawyer.
I guess it's Dr. Justice Shremsai. You say his lawyer, is it for Big C or for Ato Forcing?
I think for the defense.
For the defense?
Yes, for the defense. I don't really know which of them, but I read it.
Whether it's Ato or...
He is on record. I read it. And please, if what I read is wrong, then it must be attributed to what I read. That he expressly stated that at all material times of this alleged conversation with the Attorney General, this man was not represented by a lawyer.
Right.
If he was not represented by a lawyer, nothing stopped the Attorney General for engaging him one-on-one. As to the purpose for which the Attorney General engaged him, if indeed it was for the purposes of getting him to turn to become a prosecution witness, absolutely nothing wrong. Many times in this our country, the Attorney General is associated in doing so, and there's a lot of common sense and legal logic in that. Because if you arrest 10 people, you want to put them on a trial, you have the burden of producing the evidence to be able to convict them successfully. And if you can get 1 or 2 to turn over and reach an agreement with you to give evidence, nothing stops the Attorney General from doing it. Only the Attorney General has got the power to prosecute people in this country. And for purposes of that, the Attorney General can decide who to prosecute, who not to prosecute. He need not give a reason to anybody for what he does. That is what the law says. And what it means is that for the purpose of prosecuting a matter, the Attorney General can compromise any of the witnesses. By compromise, I'm talking about an agreement, an understanding with that witness to switch to the side of the Attorney General for some concession that they can make. Either he may not be. Sometimes they even convict the people, but restrain the court from sentencing until the end of the trial. There are all kinds of bargaining deals that exist in real practice. So the first point that I like to make is that all the hue and cry about what is going on now, if indeed the Attorney General, engaged this gentleman, as they say, and he engaged him at a time that this man was not represented by counsel, nothing. That's absolutely, I can repeat that 100 times. But the first point I like to make is that if the allegation is right, Attorney General committed no error, nothing wrong at all. That's first point.
Right. But before you proceed with that, but we've also heard a counter argument where some lawyers will say, per your legal profession rules,
yes,
because the accused is vulnerable,
yes,
and the person is fighting for liberty,
yes,
the last thing you want to do is to try and get the accused to be on your side without a lawyer. You're trying to get the accused to be on your side.
Yes.
Without a legal representation. Now, because the person is vulnerable, you are likely to be able to get the person to come on your side because they want their freedom. Okay? Whereas if they had a lawyer with them, the lawyer with them would have advised as to whether to go or whether to agree or not to agree. So your own legal profession rules actually insist that you have a lawyer present before any such discussion takes place.
There is no such law in this country. You see, the argument is a moral argument, and it's built on some attitude or some impression or some logic seeks to.
I've heard about your legal profession. We'll
come there.
56 Rule B, and it's explicitly stated there. It's supposed to guide your own conduct and action.
We'll come to that. That's fine. Let me clarify the point.
Okay, please do.
There's an impression that lawyers are the only people who are smart enough to know their way around courts.
Okay.
Please, take this from me. Only the educated and the rich in Ghana can afford lawyers in criminal trials.
Right.
About 80% of the trials that take place in this country that involve the lowly ranked people and whatever, no lawyers get involved. They are not involved. And it does not make the accused persons in those trials less vulnerable. There are some of the accused persons who are smarter than lawyers. I can state that very clearly.
Okay.
And it's only in Ghana that people think that you only proper defend yourself when you have a lawyer. So the impression that is being brought as if it is of the essence of a criminal trial that you must have a lawyer, it is not founded on either law or logic or anything.
What is it founded on?
It is founded on a popular perception that maybe lawyers are smarter and don't know their way around everything that they do.
Are you suggesting that if I was accused of something and the Attorney General intends to have a meeting with me, I don't necessarily have to have a lawyer around?
No, that's what the law says. Because if you want to have a lawyer, let me tell you what.
Okay.
Some people, they know enough about their own cases. They have good reasons, whether for bad or for good, for not engaging a lawyer. And in any case, nobody can compel anybody. Somebody can just not afford the lawyer's fees. As simple as that. But even for those people who've got legal aid, that is to say, if they wish to apply for legal aid, but I'm not sure that a lot of legal aid, is available to people in criminal trials and stuff like that. Okay. It's only in cases of murder and stuff like that, that capital punishment, that's most of the times the judges would intervene to apply to the state or to the legal aid board to find lawyers for persons who have been accused. But there's no law that says that a person must have a lawyer before he can have his case heard in court.
But isn't it also true that per your practice,
Yes,
you're not only guided by law, but you're also guided by rules?
the rules do not make it compulsory, with due respect.
Okay,
If you have a case, it's a choice whether you want to hire a lawyer or not.
I see.
No, it's not even how serious the case is. It's your choice. And that choice is informed by various judgments that you have to make. For instance, first is the cash. Can you afford the fees? If you can't afford the fees, there are all kinds of reasons. And besides, like I've said, some people are smart enough to know their way around the court without necessarily hiring a lawyer. So let's not make a fetish of lawyers in criminal trials. The evidence does not support it. And the people who are aided by lawyers in the court, there's no guarantee. People believe that when you've got a lawyer, your chances are far better of maybe being acquitted and so forth and so on. But it is not the law that you must have a lawyer before, number one, you can defend your matter, or two, if you want to do plea bargaining or want to do any negotiations, it is not the law. So what the law says is that if you engage or you intend to engage a person who is being tried for a criminal offense, and the person has a lawyer, having a lawyer is a matter of record. The court's record will show that this person has got a lawyer. It is only in those circumstances that when you have a lawyer, that the Attorney General in this context, it's not only Attorney General who pushes cases. Don't forget that down the lane, there are all kinds of representatives for the Attorney General, though prosecution is not done in the name of the state and by the Attorney General, and everybody who prosecutes a matter is deemed to be acting on the instruction of the Attorney General.
Right.
But the point I'm making is that there is no law, no obligation on the Attorney General before he wishes to settle a case or do out-of-court negotiation with anybody to ensure that the person has a lawyer.
Okay.
If the person himself thinks or desires to have a lawyer, it is his choice.
Okay.
And when the engagement takes place, it does not fall foul of any law in this country. That's the first point.
Okay.
But if, as it is being alleged, the Attorney General engaged this gentleman with knowledge that the person was represented by a lawyer, it's a question of fact whether the allegation is true or not. And if that allegation is true, I'm assuming in the worst case scenario, the allegation is true, that allegation by itself has got no consequence whatsoever for the matter that is being tried before the judge, before whom the matter is being tried. Because whatever takes place outside the courtroom has different consequences. So, for instance, if it is being alleged that the Attorney General engaged this man at all material times when he had a lawyer, then it is for the lawyer to make an assessment, the effect, the impact, the consequence of that engagement of his client. Under normal circumstances, if that allegation is true, then it can give rise to a question of impropriety, an allegation of impropriety.
Okay.
And that impropriety arises from the fact that the law itself has made it clear that for purpose of engaging in an out-of-court settlement, if a person has got a lawyer, you must engage the lawyer.
Okay.
So like I'm saying, it's a question of fact.
Okay.
And I would have desired that in the facts or in the circumstances of this case, it would be left for the lawyer to state that on so and so date, there was this engagement, and there was this engagement. At all material times, I was a lawyer.
Okay.
But that question goes to ethics.
Okay.
And it's got nothing on the substance of the case that is before the court. And the forum for the determination of the question of ethics or etiquette rules of conduct is a forum other than the court before whom the matter or before which the matter is being tried.
That's with the General Legal Counsel.
That is so.
Right.
Even though I've heard argument that the Attorney General is not liable to the rule of the General Legal Counsel.
That's another argument on his entirely different argument.
I've
yes.
heard argument. I remember there was once that I tried to report a senior state attorney and the General Legal Counsel said they don't come under their jurisdiction. So that's a different argument.
Right.
But then the point really is that even if that were so, it has no effect, no consequence whatsoever on the matter that is being tried. On the contrary, if the lawyer, whoever who is the lawyer for this accused person, have cause to believe or think or suspect that what is happening or what has happened or the allegation that founds that story is true, then he can bring an application before the very court, before which the trial is taking place, to seek any appropriate remedies or appropriate relief, including the possibility of possibly, informing the court that maybe what has taken place has compromised the whole suit, and you have to lead the evidence to demonstrate as a matter of law how that engagement with your client has affected or is likely to affect or has impaired or is likely to impair the judgment of the court on the facts or the matter before it.
So in this case, we're talking about Tajosori, because Tajosori is not a lawyer for Big C. Okay. And you're saying that it's Tajosori who should be initiating.
That is so. It's not
such a
political
complaint
party
to the General Legal Counsel.
That is so.
That you
Or
had
an
an
alternative.
engagement. You had an engagement with my clients sometime back.
That is so. That's the
and
proper thing.
per so and so grounds, I believe that this could potentially compromise the outcome of the trial.
That is so.
And so General Legal Counsel look into it.
That is so. In the absence of General Legal Counsel, it's not only the General Legal Counsel. If you have got reason, cause to believe that the interaction between the two parties affect the substance of the matter before the court, whether procedural or the real substance of it, if you've got any reason to believe that the mere contact between the two people has somehow compromised the matter before the court, then you bring a proper application before the very judge before whom the proceedings are taking place. But let me show you what's happening now. I don't know the timelines that anybody has given for these so-called meetings. Question is, why would it take now?
Right.
Why would it take now for these matters to be coming up now?
Why does that matter?
It matters because under our rules of engagement,
yes,
before the trial takes place, you file what we call witness statement. Your witness statement contains the material facts on the basis of which you intend to invoke the position, the law, the legal, whatever that flows from those legal facts. Because what we do in court is to lead evidence in support of material facts. And therefore, it's my view that if they really intended that this witness is coming to court to make those allegations, and that allegation that he was making it in the honest belief that those allegations somehow ought to affect the outcome of the suit, then it should have been in his witness statement before the court. And that will put even the prosecution on notice that this allegation is going to come up. And
pardon my ignorance. What if at the time, or at that time, the person was not privy to this information?
Good. We have room for what we call amending your witness statement.
Okay.
You see, you're supposed to put the material facts before the court by a witness statement, which is, not sworn to, but of course you depose to it as your...
Yeah, the day that Richard JAKPA drummed that bombshell,
yes,
apparently all these materials we're talking about, the WhatsApp chats, the audio that was played at the presser, and some other materials that Richard JAKPA's lawyers deemed to be relevant as far as the trial is concerned. All these materials were put before, in fact, have been handed over to the court. So the court is privy to all of these. Or you still have a challenge with the timing? Because this was just a few days ago.
No. I'm making a statement. It may be based on ignorance.
Okay.
In other words, I do not know for a fact that the basis of this allegation was already before the court. If the basis of this was before the court, then at the end of the trial, the court will assess that evidence in the light of all the evidence that is before the court for the purposes of making a simple determination whether or not the parties before it are guilty or not guilty. And if it is so, then it is even worse that the public or the political parties have not taken upon themselves to debate a matter which is before a court for determination by a judge. That is even worse, criminal. It can give rise to criminal contempt of court. Because when a judge sits on a matter and the judge is required to give judgment, it is a contempt of court for anybody to discuss the matter before the court in a way as to suggest that one party is right and one party is wrong, or one party must be believed and the other party must not be believed. It is contempt of court. And that is how wrong, in my view, all these discussions can lead people into serious trouble with a court. Because any time that a court has a matter to determine that would one way or the other, it is not proper, it is not right for anybody. It's even worse when it's being done by lawyers.
Does it again? I still want to go back to the issue you raised, and you said there is no law. There's no law that actually supports the argument that when you are talking to if a prosecutor is talking to
An accused person. Very right.
they must necessarily be present, the accused person's lawyer.
No.
You're saying there's no law that backs that, and that is more to do with it's discretionary. That's the point you're making.
Yeah, because the person is not bound. See, nobody's bound to hire a lawyer.
Does it matter whether indeed, or does it matter does it matter whether or not at the time you're talking to this accused person, the person had a lawyer, but you chose to speak to the person directly?
That's wrong. It breaks our ethical rules of conduct.
Yeah, so that's the thing, because at the time.
But that's an allegation.
Well, that's what I'm saying. So everything we're talking about here is based on the tape that's been played. Now, this tape that we're talking about.
No, but it's a question of fact whether or not this gentleman had a lawyer at the time.
Yes, I'm told he had a lawyer called one lawyer. Is it Akuna or something? Yes, he had a lawyer at the time, because this was in 2022. This conversation is in fact this was something that happened some 2 years ago.
I will ask you a question.
Yes, and I'm told at the time he had a lawyer.
You're right.
Yeah, of course, he terminated the contract he had with Ola, and then decided to hire the services of Thaddeus Sori. So yes, per what we have been told, this man we're talking about in question, Richard JAKPA, had a lawyer, and that's why the NDC are raising ethical rules or ethical issues with his decision not to engage the lawyer, but rather to engage the man directly.
Yeah, but let me make it this point.
Before you come in with that, let me just quickly do this. Let's talk to Adib Sani briefly on the issue about the authenticity or otherwise of the tape in question, because that's extremely important. Adib, good to have you on the show.
Thank you, Moro.
So a tape has been played. The tape was played at a presser. The NPP holds a counter press conference, and the argument is that let's ignore the tape that's been played. It's been doctored. It's not authentic. First of all, what do you make of this? I mean, when we say tape is not authentic, what does it mean? And when you personally listen to that tape, does it look like a tape that's been doctored? Where do you stand on this? What do you think?
Well, as someone who has studied and worked professionally on forensics, including audio and video forensics, I do understand some of these things. It is politically convenient to just sit and say that it is not authentic. I mean, that is what we are accustomed to in this country. Even if it is video, it is just safe to say it is not authentic if you are caught in the acts. But my question is based on what? Scientific fact. And as a professional, I would like to speak from a scientific perspective. We do agree that the world has changed. I mean, we are in the 21st century. Now we are dealing with the issue of deep fakes. Just yesterday, a group of scientists reiterated the fact that artificial intelligence produced political materials has the potential of affecting the integrity of the elections in the UK, which is coming up on the 4th of July, and the US, which is coming on in December. And so the issue of deep fake has taken precedence. I mean, what basically is done is, and I've used, on several occasions for study purposes, some of these materials, some of them, in fact, are open sourced. What we do is, I'll get a recording of Moro. I'll simply play it to the machine. The machine would capture it, study it, and replicate it. So what it means is I'm able to retype what I want Moro to say. So I'll put it out there, and it will be your voice. You wouldn't be able to convince anyone it is not your voice because it is your voice. So based on the face value, it is extremely difficult, almost impossible, for you to say whether it is fake or not, even though we rely on some few things to look out for example, the sequence, the ambience, mostly deepfakes are done in a noiseless.
Hello, Adib. We're sorry about that.
Environment. That is
Okay.
when you are able to insert it. Can you hear me?
I can hear you, Adib.
All right. So, like I indicated, sometimes deepfakes are done in a noiseless environment. That is when you are able to manipulate the system much more effectively. Sometimes they can also insert an artificial noise into it. All right. And when you look at it critically or you listen to it critically, you realize that there's no correlation between the two, but it would involve experts to be able to do that. Based on our layman, knowledge about deepfakes, it is almost impossible to say unless you use certain tools. Okay, some are paid for, some are free, some are even online. So when this issue came up, I subjected it to some analysis using an online tool. And the outcome is, it is not fake. It is not fake. However, there are more advanced tools that can be used to tell whether indeed maybe it's a sophisticated form of fakery or not. Okay, so that would depend on that empirical analysis that would be done based on, using some of these tools. But on the face value, it is almost impossible for you to tell whether it is fake or not.
I see. So for me, my take away from the submission is that after subjecting this audio to some empirical test, you've come up with only one conclusion, which is that the tape is not fake, it's authentic.
Absolutely. And even based on the face value, in fact, before I even subjected it to that scientific approach,
okay,
based on the face value, it doesn't look fake.
I see.
All right. So I wasn't surprised that I got that response.
Do you agree with those who say that if you're saying that this tape is fake, then produce the original?
Absolutely. Absolutely. Because we would always want to get to the bottom of the whole issue by having an appreciation of what really went on. Okay. For political purposes, some parts can be cut off, but it doesn't mean it's fake. Maybe it is edited, so to speak. All right. So we need to.
Okay. So that's an interesting point, Adib. So there's a difference between
distinguish. We have fake, which is artificially generated content. Can you hear me?
Yes, I can hear you. Please go ahead.
Hello.
Yes, I can hear you.
I'm sorry. I'm using my phone data, so calls keep coming and distracting the interview. Sorry about that. All right. So what I'm saying is there is a clear distinction between complete fake and edited. Okay. So an edited could be "I love you," then you take off the love and "I you." It doesn't mean it's fake.
Okay.
It's simply been edited. All right. So there's a possibility this one has been edited, but it doesn't mean the voices on the tape are not the voices of the good Attorney General or that of Mr. JAKPA.
I see.
Right. So based on my initial analysis, I don't think the tape is fake. And if we were in a serious dispensation, by now, I think the Attorney General should step aside on principle. All right. Unfortunately, the dispensation we seem to find ourselves, there's no accountability. In the past, much more serious allegations have been made against government appointees, and nobody leaves.
Okay.
Unless someone at the top is not happy with you.
Right.
So
now,
it is quite unfortunate.
Now, Adib, the point you made about the fact that we need to establish...
there seems not to be any form of accountability.
Okay. Now, the point you make about the fact that we need to establish the difference between a fake tape and a doctored tape is very, 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 very fascinating for me. And I'll tell you why. When you listen to the MPP's grounds or the reasons why they're saying that the tape is doctored, they're saying two things. One, that they believe that there's actually a third party, right? There's a third party involved in this conversation, and they make mention of a Supreme Court judge, right? And so they are saying that once the Supreme Court judge's voice is not in that tape, in that conversation, that it makes it fake and it makes it doctored. That's number one. Number two, they also say that when they listen to the tape critically, there are instances where certain expressions have repeated itself twice. So these two reasons for them makes the tape a tape that nobody should take seriously. But you are saying that even if we're to assume that there was a conference call amongst three people, so Richard JAKPA, Attorney General, and then whoever the Supreme Court judge is, you're saying that even if somebody had edited the voice of the Supreme Court judge, it still does not render the audio fake. So what does it render it? Doctored? Less authentic? What does that make the tape, the audio? How would you describe it?
Perhaps it has been edited.
Okay.
Okay, but that doesn't mean it's fake.
It's fake.
The question, I think, Moro, the question we should be asking is, those voices, are they that of the Attorney General and Mr. JAKPA?
Okay.
All right. It doesn't mean it's fake. All right. So their analogy of the sequence of activities that characterized this tape, I think that doesn't make sense. I mean, they are just being political and trying to save face. But if you are going to go by, it's based on the merit of the issue, you would realize that it is simply not fake. All right. It might have been edited, but editing doesn't mean it is fake. All right. And like I indicated, Moro, if truly we were a consolidated democracy, the Attorney General would have simply stepped aside for an investigation to be done. Because trust me, what I heard on the tape is serious. Witness tampering and advising someone to deceive the court. And no. This is unacceptable.
No, just going forward
on the initial.
That's fine, Adib. Just going forward briefly, you can do that in just a minute. You say that you have actually subjected this audio to some an application that you downloaded from somewhere. And you're saying that on the surface of it, prima facie, it's authentic. Now, would you, for instance, recommend as a security person that going forward, this tape that we're talking about should be subject to a much more thorough forensic audit in order to either confirm what you've just said or to dismiss it? Would you suggest that we do such a thing as a country, as a state?
Absolutely. From a third party. I mean, the state has the capacity and capability to do that within minutes. Okay. All right. However, who appoints the security chiefs? It is the president. Okay. So there might be people expressing suspicion and not have confidence in that process. So what I think is we should get a third party, just as when issues of corruption come up, the government simply refers it to KPMG to, look into it. So I think we should get a third party to analyze the tape and give us the, facts of the matter.
All right, that's fine. Thank you very much, Adib, for talking to us. It's been a pleasure.
Thank you.
All right, so I'm coming back to Lawyer Pence. So now, Lawyer Pence, this issue just raised. A lot of reaction. It's actually triggering a lot of reaction on people are sending me a lot of messages, and they are very uncomfortable with the argument you're raising that there's no law that actually supports the fact that if a prosecutor is going to be talking to, say, an accused person in a trial, the person doesn't necessarily have to have a lawyer there. There's no actually law that backs that. And you're saying that it would then bother on ethics, isn't it? That's if indeed the person has a lawyer. If you don't talk to the lawyer, then it bothers on ethics. That is so. But it's not criminal per se.
No.
Okay. And you're saying that one of the reasons is that nobody is actually compelled to hire a lawyer anyway if you find yourself in trouble with the law. So that's the first point you're making. What's the other point you're making?
The other point is all the discussions that are held with a view to resolving a matter in court are without prejudice.
Are without prejudice.
In other words, you can't quote me, I can't quote you.
So you're saying that the discussion that happened between Richard JAKPA and the Attorney General
that is so
cannot be quoted by who?
Every word of it. Let me tell you what. The context of every such meeting is for the purposes of reaching an agreement. If they had reached an agreement on what they met to discuss, the only thing that we'll be hearing today is a resolution of the matter this way or that way. But everything that was said at that meeting, which concerns the matter that was in court, is what we call without prejudice. When we say without prejudice, what it means is that you can't quote me, I can't quote you.
Interesting. Is that what you refer to as ex parte communication?
That is so.
Which must be kept confidential?
That is so.
I'll take a short break. I'll be right back. It's just a minute. So this is Good Afternoon, Ghana. We'll take a short break. I have lawyer Kweko Pento with me. He's making some very interesting legal arguments. I'll be right back. All right, then, welcome back. This is Good Afternoon, Ghana. Unfortunately, now, just when the conversation was getting interesting, we would have to leave here shortly. So somebody actually sent a message, Lawyer Pento, and the person says, without prejudice, communication can never include a conspiracy to commit crime. Any agreement to perpetrate illegality is against public policy. That's what the person said. That's in disagreeing with what you said. This one, good afternoon, Ghana. Good afternoon, sir. My name is Kojo from Takrady. Please, we want to know why is it that people who make unpleasant comments on issues in court describe as contempt? Again, why must judges warn people from commenting on cases at court? I think the learned discussant is misleading the public. That's coming from Naneya Icha. Bono Eastern BP TESCON coordinator, also Echan, says the only thing the NDC seeks to project to the Ghanaian people is to make it seem that Attorney General has done something wrong and make their usual noise, which will not win them power out of it. There are more serious matters to discuss in this country. Let's leave the NDC to their usual noise making. Also Echan sends that message. And here, good afternoon, Moro. I agree entirely with the submission of counsel. He has canvassed sound and great legal submissions. The evidence should be tendered in the court of law and not in the court of public opinion. That's kind of Sebastian. He says he stays in Spintex. So again, we may have to do a part 2 of this because we don't have a lot of time. But again, you're saying that they're saying there's nothing wrong if an attorney general or a prosecutor wants to compromise an accused person in order to achieve a certain end. If you could just clarify that briefly before you move on.
Not necessarily compromise. Everybody's got an interest in court.
Yes.
When an attorney general is charged, it doesn't mean that he's going to succeed. Right. He will successfully prosecute and get a conviction. But you, the accused person, you may also know the strength or the weakness of your case.
Right.
And therefore, we call any situation where these two parties, considering the relative positions, come together to reach a compromise, we call it plea bargaining. In a plea bargain, it could be from a total discharge to, and indeed, even under our law, the plea bargain settlement must be placed before a judge. So even in Ghana, it's that serious. Not even just the parties who can just reach an agreement and the agreement will bind the court. The judge will have to kind of give his view of the matter, and the judge is the one who is empowered to give the final verdict, if I may put it that way, even in spite of a plea bargain.
Right.
But an attorney general can even decide to discharge an accused person just for the purposes of getting him to do it.
But in this case where the Attorney General was heard, that's of course, in this case where you heard the Attorney General actually telling the man what to say and what to do, you're saying that there's nothing wrong with that?
You see, my difficulty, my problem,
yes,
the ethical conduct, the issues of ethics.
So that borders on ethic?
Well, not on the part of the Attorney General. Because see, please, when people have met, the rule is that everything that the parties discuss outside the court is in camera. It's between the two of them. Ought not to go out to the world. What people do in order to reach compromises, only God above knows. But for the sanctity of those kind of discussions, the court is not entitled to hear a word of it. The court does not have a duty to ask the parties, what did they do? what discussion did they have in order to reach that compromise?
Okay.
In the same way, if the parties fail to agree, the only thing the court is entitled to hear is whether they reach a settlement or not the reasons for which they didn't reach settlement.
But the NDC is not saying that the matter should be discontinued. They are just saying that the AG is not fit to continue prosecuting this case. That's what they're saying.
On what basis? On the basis that...
Because the AG is trying to coerce somebody to say things in order to incriminate somebody.
When I say...
Allegedly.
No, you please, get me.
Right.
When people have met in camera to compromise a suit, they met. This man's got an interest for going to meet the Attorney General, and even he had a lawyer. He's a sensible man. He knew he had a lawyer. He must have a good reason for wanting to avoid his lawyer in meeting the Attorney General.
Yes.
The idea was to seek some concession that may favor his case. And he was not obliged to accept anything. And we are now hearing what we are hearing because they did not reach a compromise.
So is that the reason the Attorney General was actually asking him not to record him?
Obviously.
Because it wasn't meant for public consumption.
Obviously, every discussion outside of court in connection with a matter in court is without prejudice. And indeed, if this matter were to find itself before the court, the judge will have a problem with the person who brings the evidence before the court. Interesting.
Lord Pencil, you know what? Can we do a part 2 of this? Because this
I'm
is
always
very
available.
Thank you very much, Lord Pencil, raising some very, 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 you may want to term it as controversial, but that's his opinion as far as his understanding or appreciation of the law is. My name is Aldumo. Thanks for watching. Good afternoon, Ghana. I want to say a big thanks to Adib Sani for joining us. Justice Abdullahi couldn't join us. He was actually catching a flight, and so he has some difficulties. I want to thank you very much for joining us. Same time, Saturday, let's continue with this conversation on Inside Pages. We'll do a part 2, a much more comprehensive conversation on this matter. Have a wonderful day. Bye-bye.